Welcome to the show. Today is Judge Victoria Shackelford. So settle in, and I hope that this is educational for you. So let me share my screen. And bigger.
No? Okay, but just so you know, Miss Henry, I can tell you're incredibly soft-spoken. She has to make a record, so make sure you speak up a little so we can hear you, okay? All right, I reviewed the pre-sentence investigative report, and I'll be honest, I'm surprised that the prosecutor charged this case. The allegation is minor at best. There's no indication there was physical contact. You threw a rock and it hit someone's boot. You didn't aim at someone's body, head, chest. You threw a rock on the ground and it hit someone's boot, and now you have a criminal conviction. And you know, you have the benefit of a diversionary status, so it's not going to be a public record. But I think it's unfortunate, to say the least. There was a sentencing agreement on this case. That it'd be under that diversionary status, so it will be. Where's Mr. Zick? Is Mr. Zick on?
This is a state case.
Oh, it's a state case, okay. There's non-reporting probation. I'm not making you report. You're not doing any of that. For 6 months. So you have 6 months in non-reporting probation. You can't pick up any new convictions, okay? You can't use drugs or alcohol while you're on probation. You understand that? And they could ask you to test. I'm not giving you a color. I'm not making you test, but I need to let you know there's always a possibility you could be tested. Okay. You have any assaultive contact with Tyler Smith while while you're on probation here. But I want to make it clear, Mr. Smith, this is not, listen, you two have a child in common, and I'm just going to be real honest and frank with both of you. You're going to screw a kid up if the two of you can't find a way to function as adult parents. You are, right? Because when you two interact like this in front of this kid or try and use weaponize the judicial system or the criminal justice system against each other, it's a real problem. And I want to be clear that you don't have to get along. You don't have to like each other at all. You can hate each other. But when you're around a kid or you're dealing with a kid, they can feel it, they can sense it, they know it. And when a kid feels torn between two people who love that child, I mean, the child's lucky, it has two loving parents, but when you are torn, when this baby or young kid is torn between the two of you, you're gonna screw this kid up. You hear me, Mr. Smith? You hear me,
Yes,
Ms.
Your Honor.
Henry? And listen, you two need to learn to get along, but my probation officer is not a babysitter. Okay, I mean, she's not. And you two need to learn to get along. Keep your hands to yourself, Miss Henry. Keep your rocks to yourself. Do what you need to do. But if you two need to go to front of the court and get something worked out, then go do it. But we're not using this court. I'm not your babysitter, either of you. So if the two of you want what's best for your kid, I suggest you both look at him sometime, or her, the boy.
Yes,
A
sure.
boy, look, how old?
2, about
Okay.
2 and 4 days.
I want you to go home and look at him. And Mr. Smith, next time you see him, I want you to go home and look at him. And I want you guys to figure out if your distaste for each other is worth screwing him up for the rest of his life. And if the answer is it's not worth it, which should be the answer, then you two play nice and get along, because I'm telling you, he is going to suffer, not either one of you. That's my lecture. I think it's terrible. You can't have any assaultive contact. You're sentenced under 7694A, and you're to obtain an order for fingerprints if applicable.
Yeah.
Anything else?
Nothing further, Your Honor. Thank you.
All right. We're all set. Have a good day. Hi, this is 2412290M, the people versus David Reyes.
Good morning, Your Honor. James Kazicki on behalf of Mr. Reyes.
Judge. Okay, before you start talking, man, what's the evidence? I'm representing myself. My name is David. Wait a minute, my name is David Mark Reyes, right? Yeah, the evidence
Okay,
is me.
Mr. Reyes.
Yes, I'm
Mr.
listening.
Reyes.
Yes,
Mr. Reyes.
yes.
Okay, I hear you, sir, and I see you. Can you just take a seat? You're so close, I can hardly see you. I can see you much better when you sit back. Thank you. Okay, so Mr. Reyes, we're here today for a pre-trial on this case. And we're going to go, and we're going to set it for a settlement conference. Okay, Mr. Reyes? One more time, sir, what did you say?
Shit, man.
Okay,
I'm not playing now. I'm not playing today. Second time I've been here now. What's the fuck the problem? Show me the evidence.
Oh, all right, Mr.
Yeah. Yes or no?
Okay, Mr. Reyes.
Yeah, hey.
Mr. Reyes.
I'm not playing today. I don't give a fuck. You're married or not. Okay, just release it. 40-year minimum.
All right, we're going to set,
40 fucking year minimum, man.
all right, I'm muting you, Mr. Reyes. We're going to set this for a settlement conference with the complaining witness to appear. And we're going to make a referral for competency, so that Mr. Reyes, so that you can be evaluated by the forensic center to ensure that you understand what is happening in these proceedings today. So for now, I'm going to do a competency referral based on Mr. Reyes's appearance in court today, even without a motion by defense counsel or the prosecutor, which defense counsel has just made the motion, but even without that, it certainly seems appropriate. So I will sign an order for competency, and we will see Mr. Reyes in a few weeks, hopefully with that report. Okay? All right, Mr. Reyes, you're all set for the day. Thank you, officer.
Thank you, Your Honor. I'm going to speak, sir. I don't know to anyone today.
All right,
He was calm and collected when I talked to him.
Mr.
I'm not unmuting or.
Mr. DeRoche, we need you to unmute. And there you are. All right, we've got someone here. And I'm asking you to unmute. Can you please unmute?
Judge Jeffrey Pan, oh, that's Mr. DeRoche's mother.
Okay, where's Mr. DeRoche?
He was there earlier. He's, again, Judge, for reasons that defense were just asking for an adjournment so I can finish the discovery and meet with him at my office.
Okay, he's got one I need to arraign him on though. And we're gonna adjourn the arraignment too.
That's fine, Judge, if he's not.
He's not willing to come on camera.
He's having a medical issue and he left the room.
Okay. I've signed the request for discovery on the new file, Mr. Fanto.
And I'll coordinate with officers.
We're going to adjourn all of these for a short time period. Mr. Fanto, I know you're a patient attorney and I appreciate that, but Mr. DeRoche has cases pending, 3 misdemeanors. And if next time he comes to court, he refuses to come on to screen and refuses to participate in proceedings, I'm going to hold him in contempt.
Understood.
And I'm going to require that this hearing be held in person. So we're gonna have, next time, Mr. DeRoche is going to come in person to the 23rd District Court, and we will hold it in the courtroom.
Thank you.
Can you give me a little bit of direction?
You should go into your app.
I mean, yeah, if you know how to help him, counsel, I didn't go to school to figure out phones. I'm sorry. I have no idea how to do that. My
I
phone
don't
is just
either,
set
but I
to do
can
that.
try. Okay, Mr. Mays, listen, you have to go to your apps. You have downloaded the Zoom app, right? So you got to go there, select out of your settings to give Zoom permission. So you.
All right, Mr. Mays, are you comfortable going forward on your motion without me seeing you?
Yes, ma'am. I have no problem with that.
So this is 24014278 LVNV funding versus Philip Mays. Counsel, can I get your appearance?
Thanks, Judge. Good morning. Attorney Ashley known as Hartman on behalf of plaintiff.
And Mr. Mays, can you tell me your first and last name, please?
Philip Mays.
All right, so this is the time and date set for a motion and affidavit to set aside a default judgment. So your allegation in your motion is that there was no jurisdiction because you weren't personally served. Is that correct?
Yes, ma'am.
All right. I have a proof of service and affidavit in the file that indicates you were in fact served, personally served.
Ma'am, if you go to they issued a brief to you. This is how I actually even found out about this. I got the letter default in judgment on a Friday, and I was wondering, I didn't know what it was about because I didn't know I was supposed to be in court. I contacted their law firm, and when I spoke with them, they told me that this was a debt that was over 8 years old, and that I was supposed to be in court. I never knew anything about that. If you go to their brief and you look at their brief on page where he said he served me, he didn't serve me. It's saying that I'm a black man with black hair, 160 pounds, and that I told them that I supposedly said, yeah, this is me, and accepted a letter from them. There's no black people in my home. There's no way that they serve me.
Are you telling me, Mr. Mays, are you telling me you are not a black male?
No, ma'am, I'm white. I'm a
I'd
Caucasian
love to
male.
see you. I'd love to see you. If I could see you, we could resolve this real quick. Because
could
they
come-
served a
I
black
could come to your
man.
court, ma'am, I could come to your courtroom right now with my driver's license.
All right, I'll see you in a minute. Come on up, I'll see you in a
I'm on my
minute.
way. I'm on my way.
All right.
All right,
I
bye-bye.
mean, Miss Nonis, they served a black man. We'll see, Mr. Mays, we'll see you as soon as you get here, okay?
I'm on my way, ma'am. Thank you.
This is why it's so important, and I know it's not, there's nothing you can do about it, but this is why it's so important for me to be able to see people in court, right?
No.
If I could see you, I'd grant your motion right this second.
Okay, well,
So
you're gonna.
come on in. I'll see you in a minute.
I'm 10 minutes away. All right, bye-bye.
All right, thank you.
Yes, ma'am.
Officer, you want to come on up? Hi, come on up, sir. Well, do you have it?
Yes, ma'am.
All right, let's see it. We're back on the record on 2401-4278 GC LVNV funding versus Philip M. Mays. Council's present. Can you turn around so council can see the cameras up there? This is not the guy that was served. That's for sure. I've seen his driver's license. This is definitely Philip M. Mays, and he is listed as a white male. Okay, Mr. Mays, your motion's granted.
Ma'am, can I say something before we quit? Are they gonna be able to bring this up against me again? Because for one.
Yes.
Well, for one, they said that this is an 8-year-old debt. I never been contacted as far as trying to find out if it is even me that made the debt. I have a brain injury that I was diagnosed with from a car accident. I can't remember how long ago. So I don't remember things like that. The only outstanding debt I have right now, all my debts are paid 100%, is a hospital bill. And I've never even been contacted by these people, which is what's got me kind of confused about this. And according to MCL.
One sec. Well, if you're are you gonna quote me a statute about a statute of limitations?
Yes.
Okay, I know it. All right, there are ways that, let's hear what Ms. Nonis has to say real quick, but I know the statute. I understand where you're going.
Okay.
Counsel?
So thanks, Judge. So a couple of things. First and foremost, with his motion being granted, obviously I don't object. I would agree with that. I would just ask that it's still set for a pretrial. Have him file an answer. I can get him the documentation and we can go from there with the pretrial. Because here's the thing. I mean, we are going to assume again, it is within the statute of limitations. He clearly says he just doesn't remember it because the statements are addressed to his name, to his current address. So to avoid wasting the court's time, wasting his time.
Has he made payments? Well, let me ask, has he made, I mean, if it's 8 years old, did he make payments up to the up to 6 years?
When was the last payment?
So the last payment made was in October of 2018, which when we filed suit, it was in the statute of limitations. I believe it still would be in the statute. So yes, payments were made on the account that brings it in statute. So it's not past that.
Well, can I ask you what was the amount on the payment? The last payment you said? $66. And you're saying I owed how much on this credit? What was the credit at?
Another morning walk. With our mom's osteo.
The current balance that they're pursuing is $1,314.68. That's the amount that was remaining on the account after it was charged off for non-payment.
Was it from a credit? Was it from a store or Myers or something like that?
Sir, this was explained to you when you called in the office. It was a Macy's credit card that was addressed to your name and to your address.
Macy's credit card.
So, sir, I'll tell you the way the statute of limitations work. If you continue to make payments and continue to acknowledge that it's not necessarily 6 years from when the debt was incurred.
Yeah, but if somebody took this out in my name and they've made a couple payments to make it look like they was in compliance and
Well,
then
that
just
would be a
stop.
defense that you would have going forward, that
Oh,
we
no,
could
I'm
have a
gonna fight
trial.
it. Yeah.
Listen to me, okay? If you had a defense and it wasn't you, or it was fraud, those are defenses that you would present at a hearing,
Okay,
right?
yes.
Um,
Okay, that's fine.
so there's paper, so I don't know anything about it except for what the two of you just told me. But sir, you can go down to the window, Mr. Mays, and you can file do you have the complaint with you?
Yes.
The paperwork? Did you receive you're saying, we know you did.
Yeah, I have the one that I got when I found out I was supposed to be in court. Can I get my $20 back? Because they made me pay $20 to reinstate.
Yes.
I don't think that was that funny. I mean, if I knew for a fact I owed this, is there any way you can show me like a signature? Can you show me my signature?
This is what we're gonna do. Listen, this is what we're gonna do. Ms. Nonis, Mr. Mays. I'm going to set a pretrial, okay? And we will have discussions at that time, and you two can have discussions leading up to that. And then we'll have a period where she has to give you all the documents they have to prove the debt is yours, right?
Yeah.
You have to give her any documents you have to prove it's not you.
Okay.
Okay, and then ultimately you're entitled to a trial at the end of all of that, if you want one. People can file motions to get rid of the case that way. But for now, it's clearly not you that was served. So we're past that.
Okay.
So I'm going to ask you,
All right.
I'm returning your $20, all right? I'm asking you to go downstairs
Okay.
to the windows, to the civil clerk, and ask to file an answer. And they actually have the paperwork down there. You can just fill it out before you leave. Okay? And there are also defenses. And if it's not you, you can fill that out too and check the boxes saying why you think this isn't your debt or why you think you're not responsible for it. And then we'll have a pretrial. We'll come back in a few weeks, okay?
Mhm.
Just notice I'm giving him a little sticky note that says answer and affirmative defenses, so he remembers what to ask for downstairs, okay?
Yeah.
Can you, Miss Officer Frisky, can you get that to Mr. Mays? Those are the two documents you need downstairs. Now, you're going to need a copy of the complaint to answer and you didn't get it, so I'm gonna have to give you a copy of the complaint as well.
Thanks, Judge, for doing that.
Yeah, I'd rather. I mean, I can dismiss the case. It's not, we could do this all kinds of ways. The reality is, this is Mr. Mays. He's here. It just makes more sense.
Mhm.
I think it should be dismissed, and I think they should have to refile because it was.
Well, they wouldn't have to refile. All they'd have to do is get service on you.
They come send service now. I'll be at my address.
Why though? You're here right now.
Because
Mr. Mays.
I feel like they're being deceptive by saying that they come to my home and there was a black man answered
Well,
the door.
Mr. Mays, can I answer something for you? They used a third party. It wasn't someone from her office.
The
that
man
did
was
that.
licensed. He's a licensed server.
I know.
So he should have,
I agree with you, that just like the court relied on that paperwork, they relied on that paperwork. I don't know your race.
okay, well, all right, that's fine.
All right.
I'll find out what date the last payment was made or whatever. and-
Yeah, Mr. Mays, she's going to have to give you all of those documents. We'll set this, I appreciate you coming up so quickly, okay? Ms. Norris is gonna have to give you all of that. And I've just given you some of it, all right? But I wanna make sure that you're able to answer this. And that we can go forward and you can put forth all of your defenses. And the only way you can really do that is if you know what the allegations are, right?
Yep.
So you go downstairs, you fill out that paperwork, and then I'll try and get you a court date within the next few weeks. And Mr. Mays, if you're frustrated with Zoom, I know you said you only live a few minutes away and you sure got here quickly. If you prefer to come in person, you're always welcome to come in person. If that just works better for you, okay?
All right.
All right, are we all set?
Yep.
All right, and this is gonna take them a couple minutes to get this file down there, Mr. Mays. So they're not gonna know what you're talking about when you say that you're supposed to get your $20 back. All right, so give it a couple minutes to get down there, because I have to write everything that just happened on the file and send it down the tubes, okay?
Okay, then.
All right, sir, you're all set. Thank you, Ms. Notice. We'll set you another day.
Thanks, Judge. I just have a question. Are we off the record? Because it's just general knowledge question.
You want to be off the record?
I mean, yeah, that way I guess I don't sound ridiculous, but I just had an inquiry about you refunding the.
Okay, this is 241410, the People versus Lloyd Sanders. Can I get your parents?
Yes, good afternoon, Your Honor. James Kazicki on behalf of Mr. Sanders.
Mr. Sanders, can you tell me your name?
Yes, ma'am. Lloyd Sanders.
Okay, Miss Havner's on her way up, so, oh, here she is. Hello, Miss Havner. Can I get your appearance?
I'll take it on there and you have probation.
So this is, I just want to make clear for the record, Mr. Sanders was just here, was this last week?
It was on 1/9.
1/9 for a first technical violation on his probation. And he was here and he had this technical violation for failing to enroll in testing by 12/7 as directed, failing to appear for oversight appointment as directed, failed to appear for ISP status hearing as scheduled. And Mr. Kazicki, it wasn't you, it was Mr. Fanto, but at that time, Mr. Sanders had just gotten out of treatment. And the idea was we'll just pause that until when?
2/6, next week.
February 6th, to give him a chance to get acclimated and get everything going, and then we'll see how he's doing. So that was his first technical, which we haven't had a hearing on. So that will now be the second technical. And this will convert to a first unless are we doing them both today?
Yes, Judge, if we can handle them both today.
Okay, but they're written separately. So you have a first technical, and the first technical is for failing to enroll in testing by 12/7, failing to appear for oversight appointment, and failing to appear in your ISP status hearing and as scheduled. Do you understand those allegations against you?
Yes, ma'am.
Okay. And did you go over a probation violation advice or rights form with your attorney?
Yes, ma'am.
All right, and did you understand your rights?
Yes, ma'am.
And did you sign and date this form, sir?
Yes, Your Honor.
Okay, and the maximum possible sentence I can give you on that first violation under Michigan law is 5 days. You understand that?
Yes,
5 days counting. So you understand you have a right to a hearing, and at that hearing, it would have to be proven by a preponderance of the evidence. That's like 50% that the violation occurred. Do you understand that?
Yes, Your Honor.
And you understand if you enter a plea of guilty, that you'll be waiving those rights to a contested hearing.
Yes, Your Honor.
We're not going to have a hearing if you enter a plea. That makes sense, right?
Right.
Okay. To the allegation that you failed to enroll in testing by December 7th, how do you plead?
Not guilty. Or guilty.
Guilty?
Guilty,
Did you
yes.
enroll in testing by 12/7?
No.
Okay. That you failed to appear for your oversight appointment with Ms. Havner as scheduled, how do you plead?
Guilty.
And to the allegation you failed to appear for ISP status hearing as scheduled?
Guilty.
All right, I'll accept those pleas as knowing and voluntarily given. And I'm going to, Ms. Havner is not recommending jail on that first violation. We'll get to, or is your recommendation remain the same on that, Ms. Havner?
It does. I did tweak it today since I was able to get him on the phone with Dewin. He has an appointment with Higuera on 2/4 at 9 a.m. next week. So I just amended that, and then he has to enroll in 10 testing upon release if he does get jail for the second
All right, so I'm going to adopt the recommendation. He's already enrolled in testing now. I know the allegation is he's not going, but he's enrolled.
Yeah, yeah.
Okay, so
Yeah,
I'm not,
re-engaged, sorry.
so that's, doesn't need to be, ordered because you've already done it. You're to attend your substance abuse evaluation on February 4th, which is next week. You're to complete an addition, you have 2 additional days of community service in the city of Taylor within 28 days. So that's the sentence on the first technical violation.
And Judge, if I could, the reason why I still left as enrolled is because he would like to go to a new agency. ADCS, they just opened up a facility in Westland, and we completed the referral today. So
For what? For
he-
drug testing?
Yes, yep, it's a facility. It was the one that's out of the 16th District Court, and they had other locations in Highland, Michigan, Detroit. They just recently opened up new locations. I believe like Pontiac, East Point, and one west is Westland. He does live in Canton, which would be more feasible for him.
That's what is, as long as he's testing and in compliance with what you've agreed with him on, I'm fine with that. All right. Now we have the second violation. I can give you 10 days on this. That's the max.
Yes, ma'am.
And the allegations here are that you failed to test as scheduled on, you are not off to a good start, sir. January 11th, 16th, 18th, 20th, 21st, 23rd, 24th, 26th, and 27th. You understand that allegation?
Yes, Your Honor.
That you failed to appear at your status hearing on January 21st. That's a violation. And that you failed to attend 2 pro-social meetings weekly since January 13th. And that you tested positive for cocaine on January 30th at the probation appointment and admitted to use. Do you understand all those allegations?
Yes, Your Honor.
And again, you understand the advice of rights form that you went over and signed and dated. If you enter a plea, you'll be waiving the hearing rights, right?
Yes,
And waiving the presumption of innocence, because you're pleading guilty, if you plead guilty. You understand all of that?
Yes, Your Honor.
All right. The allegation, that you failed to test on January 11th, 16th, 18th, 20th, 21st, 23rd, 24th, and 26th, and 27th, how do you plead?
Guilty.
To the allegation that you failed to appear for your status hearing on January 21st, how do you plead?
Guilty.
That you failed to attend 2 pro-social meetings a week since January 13th, how do you plead?
Guilty.
And that you tested positive for cocaine on January 30th at 25 at your probation appointment and admitted use, how do you plead?
Guilty.
Mr. Gazicki?
Yeah, I know there's a recommendation incarceration. There's a lot of violations. I'm aware of that. Also aware that he's scheduled for inpatient next week. Mr. Sander acknowledges he's got a major problem. He's having a hard time to cope. And I don't think really the jail, I'm no expert. I don't think jail the place for him to rehabilitate himself. I'm asking the court to hold that jail in advance. He has support. He has his mother here. His violation was because he was with the wrong girlfriend, correct?
Yes, sir.
And he's not seeing her now. So I'm asking the court not to do the 3 days in jail. He works, he has to pay his child support, and obviously be, children involved in this situation if he doesn't pay his child support.
Okay.
So I'm asking for to delay the sentencing on jail.
All right, thank you, Mr. Gazicki. Look, I'll be honest with you, Mr. Sanders, I'm limited in how much jail time I can give you. The max I can give you right now is 10 days. And I know you have an appointment to start your treatment next week. And that's the only reason you're not getting 10 is because part of being in the intensive probation program is to get you treatment, right?
Yes, ma'am.
But you've done inpatient, you know what you're supposed to be doing, and you're not doing it. And like trying to blame it on a girl is like, I just heard strawberries infused with alcohol, like I hear everything. So I know this is all a girl's fault. This is all your fault. And you, listen, you had a felony reduction. Again, I don't have anything to do with plea agreements. You had a felony reduced down to a misdemeanor, right? You get this benefit, and all you have to do is comply with probation. And right now you couldn't possibly be doing any worse than you are. right? And before my hands were tied by the legislature, if you were in front of me before this change in the law, I would literally just give you 90 days right now, or however many I could give you, 6 months. And then I would just close the file out and be done. Like, that's what I would do. But I have to let you violate 2 more times before I can do that. Right? 2 more, and I can do it. And if you continue going the way you're going right now, like, this is going to be very easy for me. I won't lose a wink of sleep. I'll just put you in for your however long I can and keep society safe for as long as I can. And then,
the worst state to live in right now is Alabama, and nobody's talking about it. I spent 30 years in the insurance industry. What I'm about to tell you will explain why Alabama pays more for car insurance than any other state in the country, and how you could fix it and save up to 80% on your rate. Let me make this simple. If you're paying over $75 a month, you're being overcharged. Drivers in Alabama are being charged almost 2 times more for the same coverage compared to the rest of the country. Because you pay the most, the industry sees Alabama as one giant cash cow, and most people have no clue why. You have the lowest claim frequency, are the safest drivers in the country, and still pay the highest rates. And here's the part no one talks about. Most people don't realize there's a new way to force them to recalculate your rate because no one told you yet. My best friend Alan lives in
you'll be done with this court. That's my plan. If you can't comply at all, that's all we're doing. We're just waiting for you to do this 2 more times so I can throw you in Wayne County. Okay? I don't know what you're thinking. Like, you just don't show up. Like any other person before the legislature in their infinite wisdom changed the law and tied judges' hands with what we're allowed to do when we have much more exposure to the people in front of us. You'd have gotten it, and almost any judge would have given it to you for this violation alone. So Ms. Havner's recommendation is that you do 3 days jail. You're going right now. And that you get a peer recovery coach through GrowthWorks, and you're going to start attending that as well. And you're also going to continue with all the other conditions. And when I say continue with the conditions, I mean actually do the things, right? And just know when you get out, I think you should be in jail right now. So you can prove me wrong, or you can prove me right. These are your choices. But what you're doing right here, this is not acceptable. We're going to give you a chance to show up to your treatment, to take this seriously. But if you don't, then you could just go do your time in county, and none of us have to go through this anymore, because you're off to a terrible start, sir.
Yes, ma'am.
All right.
Judge, if I could just have him initial and sign the peer recovery form so I can get it sent over before he.
Sure. We have an excellent peer recovery coach that you could work with. If you want help, if you want to be better.
Yes, I do.
And Mom, don't fall for his nonsense. Don't fall for what he's selling,
What's that?
because he's full of it.
I'm sorry.
And the only way treatment's going to work for him is if he's not being enabled by people who love him.
All the next doors are going downtown.
He's going downtown.
Right.
Unless they decide to hold him next door, the paperwork will be for county.
Okay, thank you, Judge.
All right, thank you.
The video is too
Hi, officer.
Hi, Your Honor.
Who's first?
This is Kola Nagowski.
All right.
She doesn't go by side of Oakland County.
All right.
Come up here to the door. Huh? Well, I don't know. That's up to you, I guess.
Ma'am, can you hear me okay?
Yeah, I can hear you.
Okay. This is 202252, the people versus Kimberly Elizabeth Kolangowski. Ma'am, can you tell me your name?
Kimberly Elizabeth Kolangowski.
All right, ma'am. You're here today to be arraigned on one charge of drug paraphernalia. You, Mr. Fanto, a defense attorney, tried to meet with me and he advised the court you did not want to meet with him. Is that accurate?
Yeah, that's accurate, because I did make a statement a while here. She's sure you don't want to hear this, but I came in with my panties to my ankles and naked all the way to the police station. My rights felt violated.
Okay. Do you have pants on now?
Yeah, but the fact of the matter was I was naked all the way up until the police station and back of the car. I felt very violated.
Okay. Well, you'll have an attorney you can discuss that with.
Whatever. And they did read me my Miranda rights here.
Okay, so I have the Taylor case. It's a different case number than the one I have. Hold on.
I just tried a statement for why I was in the bathroom.
See this 244535? I only have the 20.
Oh, she was picked up on the warrant.
Okay. All right. So ma'am, you were here previously. You pled guilty to 1 count of paraphernalia. And then you were to be sentenced, I'm talking, listen up. You were to be sentenced back on December 15th of 2020, and you never came back to court. So you've been in warrant status on this file. You've been in warrant status for years now. You understand that?
Yeah.
Okay, so we're here to arraign you on your bench warrant. You have a choice. You can plead guilty, not guilty, or stand mute. If you stand mute, I'll enter a not guilty plea on your behalf. So to that first allegation, how do you plead?
I'll do mute.
All right, I'll enter a not guilty plea on your behalf.
Just because I'm a little overwhelmed with getting brought in naked and everything.
Ma'am, I don't know anything about the circumstances of your arrest.
Male cop couldn't touch a female, but apparently that I was told that they can and that there is just a courtesy thing.
All right, I'll learn more about that. I'm certain the case is assigned to me, but I don't now. You've been arraigned. You have a not guilty plea entered. We'll set a sentencing date. It looks like you showed up for the probation visit. Ma'am, I need to tell you your constitutional rights, okay? You've been brought in here on this misdemeanor charge. Misdemeanor punishable by up to 93 days in jail and a fine of up to $500. Okay? That's the maximum I can give you.
Excuse me, Ms. Wagaman, Jeffrey Fanto, Ms. Wagaman just asked that she be sent back for a new PSI because it was 4 years old.
Okay, all right, so that's what we'll do. We'll send it back for a PSI. Ma'am, you have a right to an attorney at public expense. If you can't afford an attorney, we'd appoint one to represent you. And I will make a counsel available to you at your next court hearing, okay? You have a right to a trial. Well, you've already pled on it. So, I mean, I guess your advice or rights at this point don't really.
My rights don't matter. My rights don't matter.
All right, we'll read them all. What has given you that impression, ma'am? From this court? No, you've been in front of me for all of like a minute and a half. Have I been rude to you?
I'm sorry.
Have I been disrespectful to you?
I was just violated and nobody seems to care.
Did I violate you? No, but the Taylor police did. Okay, but didn't I tell you the case is assigned to me and the attorney can look into that? Do you want me to walk over to the Taylor Police Department right now and like shake an officer down? I can't do that. But if something happened and it was inappropriate, that's why I'm giving you counsel so that you can talk to your attorney about that.
Thank you. I misunderstood you. I'm sorry.
But you're only here, I'm arraigning you. There's a violation. The allegation is you never showed up for sentencing. So I can read you your rights. You have a right to a trial, but you've already had entered a plea. You're just here because you didn't show up for sentencing. So I just want to set a PSI date so you can meet with the probation department and get a new PSI, and then you'll come back here for sentencing, okay? And you have, ma'am, you have warrants out of, you have a no bond hold out of Oakland County. So Oakland County's they're coming to get you. You have warrants out of Dearborn, Plymouth, Garden City, Westland, Ecorse, Lincoln.
I understand. You don't have to keep telling me that.
I do have to tell you that. I have to. I'm not, listen,
Get away with
you're here to listen. I'm being very patient with you. You're not going anywhere, so it doesn't matter.
I know it doesn't.
Okay. You have a $1,500 cash bond. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released, and you're to immediately notify. All right, I see Mr. Phelps is back out. I'm trying to get, oh wait, we have ASM Properties back out. We have Mr. Ruark here. This is 2501-0741 ASM Properties versus Blair Bailey and Sterling Phelps. Counsel?
Ron Ruark for the plaintiff, Your Honor.
Mr. Phelps, can you tell me your first and last name?
Sterling Phelps, P-H-E-L-P-S. Sterling
All
is
right,
regular spelling, S-T-E-R-L-I-N-G.
Thank you, sir. All right, so we've had, you've had an opportunity to meet with Lakeshore Legal. It's my understanding that you did not qualify for representation through them. You've also had a chance to speak with Mr. Ruark at this point. And then and here we are. Counsel?
Your Honor, I think we need a hearing date. There's no resolution today, and I don't see a possibility of a resolution today.
All right, we'll come back for 10/25, so April 10th of 2025 at 10:30 a.m. Are we having a full-on hearing? Is there a defense? Is this something we need to do in person?
Yeah, I don't think we need to do it in person, but at this point, we're talking about having a hearing, a full hearing, yes.
All right, then we're going to do it in person. If there are going to be exhibits, listen, wait, let me talk. If there are going to be exhibits, I don't know anything about it. I don't know if there's a defense, if he's alleging that there's something wrong with the property. If there are going to be things I need to see and testimony that needs to be taken.
Your Honor, there will be, so maybe we should appear in person. I agree.
We're doing it in person, okay? Mr. I'm sorry, at ASM Properties, sir, I don't have your name. What is it you needed to say?
Yes, Your Honor. My question is, I rented the property to Blair Bailey, and I don't even know why Sterling Phelps is living there from day one. Blair Bailey doesn't answer my phone. She doesn't answer my texts or emails. Every time we've reached out, he's living there. He claims to be Blair Bailey's father. I don't even know. Blair Bailey.
Where's Blair Bailey, Mr. Phelps? Where's Blair Bailey?
She is a traveling phlebotomist. She was here days ago. She was just here. So he is making this up. Me and him shook hands and said that I would take over this lease on this property and that I would give him my information the first weeks of the new year.
Okay. Miss Bailey needs to appear for court on 4/10 at 10:30 a.m. She's on the lease.
Right. Okay.
Court, Mr. Phelps, if not, they can seek a default against her. But the second mailing was not sent, so, I mean, the second mailing from the court was not requested, it was not sent. I don't see that she was personally served or otherwise served. So she's not in default today because she's not been served, to be here. Through alternate service or otherwise. So we'll set a hearing for 4/10/25 at 10:30 a.m. in person, and we'll have a hearing on that date. All parties are to be present.
And that's
Your
10:30, Your
Honor.
Honor?
10:30 a.m. in person.
Got it. Thanks, Your Honor.
Your Honor, if I may address the court.
Yes.
10 days ago or so, I gave your clerk, her name is Jasmine, $50 to have a jury trial. And she didn't, for some reason or another, the legal advice person just a minute ago said she didn't see it. But
I see a jury demand. I mean, we're gonna have a hearing, and then if we need a trial in front of a jury, but here's the problem. Mr. Phelps, I mean, they've listed you as a defendant, but you're not, is he in the lease as a resident or anything?
No, Your Honor.
Or an occupant?
No.
I don't think he's listed at all, Your Honor.
So is he being asked to, do you need to amend your paperwork?
Do I need to amend, Your Honor?
I'm just, if he's not there under a lease, he's not there under a lease.
That's correct.
So is this a termination of tenancy case for him?
No, we've filed it as a demand for possession. Because there's $4,700 owed under the lease. So our argument.
We're doing a jury trial on this. He's filed a jury demand and you've listed him as a defendant. If we're doing a jury demand, this date's going to be, I'm gonna have to talk to even try and find a jury date. I have criminal jury cases every Friday. And here's what I can't have. I can't have Mr. Phelps and Miss Bailey continuing to live in the property long-term and not paying rent. But I also can't get a jury here on a landlord-tenant docket in the middle of a landlord-tenant docket.
Your Honor, I would ask if we move to a jury trial that he be ordered to pay at least 1 month's rent into court escrow.
Hello.
I agree.
Or maybe ongoing rent that he owes in escrow, because there is no reason. First of all, he shouldn't even be there. He's blocking and tackling. I believe this is fraudulent because that lady is out there. We should look at his record. He's probably constantly doing this to other landlords.
Look, I don't listen. I'm not going to start looking at his record. But listen, Mr. Phelps, you have to put 1 month's rent in escrow at the court.
Arif, tell the court how much the 1 month rent would be.
Yeah, it's $1,625.
$1,625, 1 month's rent needs to go into escrow at the court. So you need to come into the court by Tuesday.
I would need that to be by next Friday, Your Honor.
You have to pay ongoing rent into that account too. So if I give you until April 4th, you're gonna have to also pay, you also have to pay this rent for April now.
Yeah, February. He has got rent unpaid since February. Actually since January.
I can't, my court recorder cannot take you down both at the same time. Mr. Phelps, what were you saying?
That's assuming that after I present my evidence, that I would owe half of this, even any of this.
Well,
that's why I'm getting it.
Look at,
that's why.
What is your evidence, sir? What is your defense?
We paid to be somewhere else for 41 days, Your Honor. And I also paid a plumber to come in here before he ever attempted to have a plumber come in here. to come into this building. The reason I couldn't pay this man is because I took over. Say again, ma'am. I'm sorry.
I'm taking a 3-minute recess because I've had it and I need a minute.
Mm-hmm.
Arif, are you still there?
Yeah, I'm here.
Let me do the talking.
Sure. Yeah, I mean, Ron, just so you know, since January, there's past due rent.
That may be true. We're talking right now about escrow payments.
Yep.
The court's going to make him pay escrow for March and April next month, so if he wants to continue with the case. But let me talk to the judge.
Sure.
I mean, she's that close to terminating the hearing. Arif, when was the plumber there that you?
So I have all the proof.
I understand
Blair
that.
called me. Yeah, Blair called me, and the very
Arif, my
next day she
question
said,
is, when was the plumber there?
yeah, I'll give you the date.
Send me the receipts and everything.
Yeah.
Send me the
We
canceled
paid
check.
$6,000 to the plumber. We have the receipt. We have everything.
You send me the invoice and receipt, and send me the proof of the payment itself, if it was a canceled check or whatever.
Yeah.
All right.
As soon as we were made aware, we took care of it. So this 41-day stuff, I will show you evidence of all the texts with her.
Okay.
And with him.
I hear you. Send me the stuff.
Yep. And I'll send you all the receipts we paid the plumber too.
Thank you.
I'm going to make it crystal clear to all of you before I ask you anything. The next person who talks over another person, especially me, is going to pay $100 for direct contempt. And then the next person who talks over, we can sit here all day and you guys can both owe $2,000 in contempt by the time we're done. Answer my questions. Mr. Phelps, are you telling the court that you had to move out of the house for a prolonged period of time?
Yes.
For what reason? What is your allegation?
There were 3 inches or so of water, sewage water, not to mention, on the floor throughout the whole home. The sink and the both sinks, the double sink and the washroom sink and toilet, all backed up. And
okay. All right. Next question. Did you contact your landlord about that? Or did your daughter contact?
Yes, she contacted him about it, yes.
Did anyone come out on the landlord's behalf to look at the problem and fix the problem?
Not originally.
Okay. Did you have someone come out originally?
Yes, TI Hardware and Sewage, yes.
Did you have to pay a bill for that?
Yes, I have the receipt.
How much?
To pay. $275. They snaked and stuck a camera in the system.
Okay. Why did you have to move out for 41 days for that?
Because my daughter said that he wasn't staying in contact with her, and he didn't feel as though the plumber that let me back up just a second. The guy that he had came out and said, hey, this guy thinks you guys tore up his garbage disposer. And he laughed and he said, this guy does
all right,
this.
I don't need all that. See, this is the problem. I need a direct answer. Was it because the house was too damaged to live in for 41 days?
Yes, there was sewage water throughout the home, throughout the complete home. Yes.
How long has it been since that's been cleared up?
Around, it was a holiday. It was either Thanksgiving or Christmas. He actually.
So why hasn't any rent been paid since then?
Because I had a problem with all the money that I spent for us to be somewhere else, and I let him know, hey, I'm going to work with you. I'm going to try to get this thing done. That's when we shook hands.
But now it's the end of March and you've not paid a penny.
Well, a month ago or so, we had an argument in which I didn't think there was anything that we could do.
Mr. Phelps, you think you could just live there for free forever?
No, he said no, ma'am. He said that he was getting the court involved and that the court would decide. And that's what
All
I
right, well,
agreed
I'll
with him.
decide. All right, nobody talk.
What does it really?
I'm deciding. You have until April 4th to submit 1625 to the court for escrow. And then every week thereafter, while this case is pending, you have to submit $377 per week.
Okay.
And that money is not necessarily going to him. That money may be returned to you based on my ruling or the jury's ruling, but I'm not going to have, when there's over 3,000 due and owing, it sounds like you have a defense, but I'm not just going to have money accruing on this. And by the time we get a jury trial date, you owe, there's a claim for $10,000. Like, that's not happening. 1625 by April 4th, I'm giving you a few extra days for your paycheck, and thereafter, you're to pay $377 every Friday at the court for the escrow account. And then at the end, I'll decide who gets what. Are we clear? Does everybody understand my ruling?
Understood, Your Honor.
All right, and Mr. Phelps and Mr. Ruark, I am going to have to find a day for this jury trial. And I want you to understand that we don't have a lot of jury trial dates. So I'm hopeful that both of you will make the date work. And I have a full expectation that Blair Bailey will be present at the jury trial. Everybody's going to be here, because if I call in residents from our community to sit on a jury trial, we're going.
Understood.
So I will get you a jury trial date. I'll take it down to my civil clerk and we'll figure out a date, and I'll try and get it done within the next 30 to 40 days. But that's the reality of a jury trial. I need to find a day.
Understood, Your Honor. I have one question, Your Honor.
Yes?
If the payments into escrow are not made, what will the penalty be?
We'll have an immediate hearing on it.
Thank you, Your Honor.
And if the payments aren't made, Mr. Ruark, I don't have time to go downstairs and ask every Friday if the payments aren't made, but if they're not made, I want you to file an emergency motion. It can be 3 sentences long, and we'll get you on the docket immediately and we'll figure it out then.
Understood.
If you saw the news.
All right, this is 250334 SM, the People versus James Crowley. Madam Prosecutor, can I get your name?
Nora Holloway on behalf of the people.
Mr. Crowley, can you tell me your first and last name?
My name's James Crowley.
All right.
Can I address the court?
Not yet.
Okay.
Was this being amended?
Yes, Your Honor. I am unfortunately still waiting on the warrant to be sent in to me.
All right. Can you talk by a microphone,
Yeah.
just so she can pick you up? All right, because I had a note in here last time we were here that this was being amended to a felony.
Yes. We would like the bond conditions to remain where they are. I was hoping to get him arraigned on it today, but unfortunately it was not sent in to me. So I'm hoping by next week it will be.
All right. All right. So Mr. Crowley, the prosecutor's indicated she intends on charging this as a felony, but that she doesn't have what she needs yet to do so. Do you understand that?
I do.
Okay. And now what was it you wanted to say to the court, sir? My understanding is you do not want a lawyer. Is that correct?
I would like to terminate Mr. Gizicki as my attorney, and I would like to represent myself as of right now. And I would like to, can you hear me, Your Honor?
Ken,
Okay,
let me tell you a few things before you go any further, because I think it's important for you to know. You have a right to
Okay.
remain silent, and anything you say orally or in writing can and will be used against you. So I want you to understand, before you make statements to this court, you have a constitutional right to an attorney. If you're firing your attorney and are you telling me there's been a breakdown of communication between the two of you?
Telling you that in no way, shape, or form has Mr. Gizicki done anything to develop a defensive legal strategy with me or take any maneuvers whatsoever.
Okay.
I'm not, okay.
So your plan is to represent yourself?
Yes, for the time being. Is it, Your Honor, am I allowed to represent myself for a time until like maybe I can find an attorney or get a court-appointed attorney that I feel more secure and confident in?
Well, we have other court-appointed attorneys here. Mr. Coots is here today. You can meet with Mr. Coots if you want to meet with Mr. Coots on the case. But I only have so many options at court-appointed attorneys, which means you only have so many options. I mean, you have a right, sir, to have an attorney at any time. And if you want to retain an attorney, you can get anyone you want. But if it's an attorney that is a public defender, we have 3 public defenders available to represent you at this court. I have Mr. Coots, Mr. Gizicki, and Mr. Fanto.
Well, then I guess my intent will be to represent myself, I suppose, for the duration of your courtroom, and then I'll just seek an appointed if they get away with increasing this to a felony. Am I allowed to object to the prosecution's adjournment?
Well, we're here today for, what's the status of discovery?
So it has been sent out to counsel, Mr. Gizicki. But if he has fired him now, I would have to send it over to him himself if he's representing himself.
All right, you understand that, Mr. Crowley? Mr. Gizicki has your discovery. But if you are representing yourself, I mean, obviously it would be.
Your Honor, if I may, last week I asked Mr. Gizicki specifically about the discovery and the evidence that the prosecution is burdened of. He told me that he has not physically received a discovery package and that he only has the police report in his physical possession.
All right, well, the police reports are discovery. I mean, that is part of discovery. And the only other thing there may be is body cam, I assume.
Yep, I would like, Your Honor, every Taylor Police body cam. I would like every phone call that was ever made to the Taylor Police from Jennifer or anybody else. I would like a record, Your Honor, of how many times the Taylor Police has been to my home in Taylor in the last 4 or 3 years.
Okay, well, I don't know that they have those records. Whatever discovery you're entitled to that's in the discovery order, you will receive.
Okay. All right. Thank you. Okay, I'll receive everything. All right. And I would like to, is this the time I could address some concerns like why I believe that my case should be dismissed today?
I mean, it's a pretrial. If you have a motion you want me to hear, then you can write up a motion or we can have an oral motion hearing. But the evidence in this case will be presented at trial. And if there's a pretrial motion you want to file, you're entitled to do that under law.
Okay,
But
so
no, I mean, we're here for a pretrial today.
all right, so I can't express myself verbally as to that. All right, copy that. Pretrial today.
Has an offer been made?
I got witnesses. I got a ton of witnesses.
Wait. I'm asking the prosecutor a question. Go ahead.
I believe Mr. Gizicki and I had discussed it, but I don't believe there was any further discussion on it. I don't know of any acceptance there was a bond violation recently, and I believe that was why those conversations got halted.
Okay.
Excuse me.
Your Honor,
Yes.
so the bond violation was ruled off a hearsay. I wanted to contest the witness that came forth, which is my own blood cousin, and Mr. Gazicki pretty much told me that I would be a fool and that he professionally recommends that I sit and remain silent as the witness defame my character. I got Romulus police stuff saying that I didn't have an issue. I can prove that she did this. My cousin made that bond hearing statement out of revenge, and I can prove it. I need Romulus police witnesses. I got all the information, Your Honor. Because
Okay.
I had to call the cops.
I've reviewed the bond hearing. I listened to the record on it. I'm aware of what the allegations were.
Okay.
And Judge Kirsten found a bond violation, and that was his ruling on the matter. So that's already been decided, sir. And a bond, I understand, has already been posted. So what we're doing right now is Miss Louie at this point is not ready to proceed on her felony case. It sounds like you're not interested in a plea offer. Is that correct?
I haven't even, my attorney hasn't approached me. The best that I know, to my knowledge, the prosecution has not offered me anything.
She said that her and Mr. Gazicki have been in discussions about a plea.
Mr. Kazicki, in no way, I give you my oath, Your Honor, that he did not say anything like that to me.
Well, he might not have told you yet because the offer, it's the only one that can make an offer is the prosecutor. Not me, not Mr. Gazicki, only her. So if she were to make an offer or they were negotiating an offer, he might not notify you of that until the actual offer's been made.
Oh, okay, I see. I understand. Thank you for your clarification, Your Honor.
Like if they're just having discussions about a potential resolution, he might not notify you until she actually says, here is an offer. He has an obligation as an attorney, once an offer is made, to notify you of that offer. So this is my thought. I'm not going to we're not going to just keep dragging this out forever. I'm setting a trial date. I see the complaining witnesses present. Defendants present. If you decide you want an attorney before this date, Mr. Crowley, you have got to notify the court. Because if you show up on the jury trial date, you can't show up on the day of trial and say, oh, and by the way, I want an attorney, because the attorney won't have time to prepare. So if you want an attorney, you have to let us know before this date so that that attorney can represent you.
Well, I guess I'm just going to go ahead. I'm just going to sink or swim by myself, Your Honor.
All right, well, I'm going to just tell you, Mr. Crowley, you have a right to do that, but I want to be clear on something. So lawyers go to law school, right? It's not fun. And then when they finish law school, they get this book. And this book is every rule you have to follow in court. There are rules of evidence. And without 3 years of law school, sir, you're not going to know them. So you're going to be upset because if you ask a question the wrong way and the prosecutor objects, I'm not going to allow you to ask the question. Like you have to follow the court rules just like an attorney would, right? And if you represent yourself, you're held to that same standard. So you might, like, I know people think they know what hearsay means, right? Because there's like a general definition of what people think hearsay is, and then there's actual real hearsay under the court rules. And I just want you to be aware, Mr. Crowley, you have a right to do it. I think it's ill-advised, but that's your choice. And we can set it for a jury trial.
This is, without a doubt, the strangest method I've ever seen to eliminate the bacteria responsible for type 2 diabetes. And the reason you've never heard about it is simple. There are billions of dollars involved in keeping you sick. A natural 15-second ritual forces your body to flush out this creepy creature and lower your A1C levels within just a few hours. Today, 9 out of 10 Americans suffer from type 2, and less than 1% know about this discovery. The real cause of type 2 diabetes isn't sugar or carbohydrates, but a tiny 1 millimeter bacterium that attaches itself to the pancreas and drains your beta cells and insulin reserves. This microscopic pest triggers constant hunger, excessive cravings, frequent trips to the bathroom, and pain in the hands and feet. The good news is that researchers from a renowned Japanese university discovered in 2023 that this bacterium is extremely weak, and that a simple trick using a handful of natural extract can destroy it in just 10 minutes. Within a few hours, you'll begin to feel an incredible relief in your A1C levels, and within days, they'll remain stable, below 4%. Now I'm going to show you how to prepare this recipe in less than 30 seconds. Just click the button below to watch, but make sure to do it while the video is still available, because this solution has made many people in the industry furious, and they keep trying to take it down. This video is being censored by those who profit from your suffering.
If we may set a settlement next week as well, because I believe the warrant should have been submitted by that point.
All right, so Mr. Crowley, for now, what we'll do is I'm going to adjourn this for 1 week. Okay, we'll come back in a week. And at that point, if an offer is to be extended, it will be extended. So if there's an offer on your case, you'll find out about it next week. Whether that you want an attorney to discuss it or you want to discuss it directly with the prosecutor, that's your choice. Okay, and then after that, we will set our jury trial. And so we'll return. Your dates are 4/21 at 9 a.m. And that's for a settlement conference. Everyone can still appear via Zoom. If an offer is made or the prosecutor's moving to make these felonies, she has a right to do that. I don't know the evidence yet. I'm not supposed to. There will be a hearing where I get to hear all the evidence and make that determination, but it's not today. And then the jury trial date, I'm setting it now so we don't lose it. Jury trial date, the next day I have is July 25th at 9 a.m.
That was 9 a.m., Your Honor?
At 9 a.m. sharp in person. But next week, come on Zoom, okay?
All right. One thing, Your Honor, anything that's going to be discussed about me or a potential settlement, excuse me, or whatever, the prosecution's going to have to go through me from now on, please.
Well, you don't have a lawyer. You've waived your right to
an
attorney, so she'll have to talk to you. She'll have to.
Okay.
Well, that's how it works. That's how the court rules work. If you don't have a lawyer, she'll talk to you. So we have bond continues. Nobody's to talk to anybody.
Yeah.
Thank you. 4/21 at 9 a.m. settlement conference via Zoom, and then jury trial 7/25 at 9 a.m. in person. It's the first date I have available.
All right.
I can get his contact information from this.
And I'll put him in a breakout room. You can get that information from him, okay? Mr. Crowley, I'm going to put you in a breakout room so the prosecutor can come and get information from you.
Your Honor, thanks for being awesome. I appreciate you guys very much.
Well, I'm just trying to make sure everyone follows the rules. Listen.
Exactly. Thank you.
Miss Ashby, Mr. Crowley, my job as a judge is to make sure people understand what they're doing and to make sure that people show up when they're supposed to and that they do not violate my bonds. Okay? So everybody is to continue doing what they're doing, no contact, and we'll put Mr. Crowley in a room so the prosecutor can get contact information from him, okay?
Thank you, Your Honor.
All right, we're all set. Who do you have first, Officer Ziegler?
Your Honor, this is, excuse me, Mr. Warner.
Okay, this is 250997, the People versus Joseph Warner.
Good afternoon, Your Honor. Robert Coots on behalf of Mr. Warner, 43430. For purposes of arraignment, we plead not guilty. Waive the reading.
All right, I'll enter a not guilty plea on your client's behalf. Mr. Warner, did you go over your constitutional rights with your attorney?
Yes, Your Honor.
Did you understand those rights?
Yes, Your Honor.
And did you give Mr. Coots permission to sign your name on that document?
Yes, I did, Your Honor.
Okay. Mr. Warner, it is so sad to see you like this. It is just heartbreaking. You know, you have really had a chance to turn your life around, and I'm just looking at you, and you're presumed innocent. It's not even about the charge, Joe. It's that I know you could do better. I've seen you do better. I should have never let you out of the program. What's up? Where's the baby? I saw you wandering Eureka Road. You had an apartment, you had a relationship, you had a baby, and you were the primary caregiver for, and now I see you homeless, back to using, living on Eureka Road. It's heartbreaking.
I got my housing in Allen Park, and these last few weeks I haven't had my psych meds, and I've just been wandering around because I don't get to see nobody. Like, nobody's allowed in my apartment, and I just have to sit there by myself all the time. I ran out of my meds.
Joe, you're back to drinking though. And that's the thing. You knew then, you don't have to listen. I'm not even your judge on this case. I'm just telling you, when you want help, it's here. Because you're clearly back to drinking. And you cannot drink. You will kill yourself. You're going to kill yourself drinking. You need help.
I know, I was thinking about putting out handcuffs or something like that and going to an actual rehab, because I just got my housing, I was doing good. I'm in anger management, I'm in AA, I'm doing that stuff. It's just, everything just started going around me this week.
Joe, you need inpatient treatment, at least intensive outpatient treatment. AA meetings will do you no good if you're drinking, okay? When you're ready, all you have to do is walk in my courtroom. I will take you down to probation. We will find you a bed and you can get better. Whenever you're ready, I am here to give you that.
Okay.
But you have to want it. You walk in, Joe, you want help, we'll get you help. You got a $500 personal bond. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court a change of address or phone number. You're to participate in whatever mental health treatment you're getting, and you're to take your meds appropriately. You understand me, Joe?
Yeah, yes, Your Honor. That's the problem I'm having, is I can't get my meds because they closed one store. They sent the stuff to CVS. I had Walgreens contacting the doctor. I can't get a hold of the doctor, and they're not refilling the meds. So I don't know what is going on their end. And then I just started falling.
You need a caseworker. You need a case manager. You need a caseworker. You need help.
I have a case manager and a therapist. I gotta get a hold of them and see what they can do for me.
When you're ready for help, I'm just sitting here waiting for you. You understand? I'm just sitting. You walk into my courtroom, you ask for help, I'll get you help.
Thank you, Your Honor.
All right. Time and date set for preliminary exam. Are the people ready to proceed?
We are, Your Honor.
All right, prior to going on record, we had a brief bench conference. Defense counsel indicated she had requested two things from the people. One was the original 911 call. It's my understanding that no longer exists. Is that accurate?
That's not true, Your Honor. I did speak to officer in charge, Detective DeGiacomo, about it. They're working on it. It may still exist. It might have been kicked out of the system.
Okay, so maybe. It's a maybe. And the other thing defense counsel would have requested was the complaining witnesses' medical records. Obviously, the people would have a obligation to redact personal information out of that, but otherwise she's entitled to them. She's indicated she can go for the exam without them. So
Judge, may I just make a statement quickly? That is technically speaking accurate. I would prefer always to have full and complete discovery prior to a preliminary examination. For record purposes, I'm asking for an adjournment. Obviously, I came prepared to proceed today. The people did provide me with a very brief discharge summary, which really contains no content. They do not have them at the present time. So I'll defer to the court on that issue.
Well, discovery's continuing. Madam Prosecutor's indicated she's requested documents. They don't have them. It's a GBH charge. There's no requirement in the jury instruction or statute that injury even be shown. It's just the intent. So I'm gonna go ahead and proceed, and we'll see how far we get today, and hopefully we'll be able to conclude, and if not, we'll find another day.
Sure. And Judge, just one other preliminary matter. It's my understanding that people intend to call a single witness. In the instance that they intend to call more than one, I'm asking for an order of sequestration. The defense has no potential witnesses present.
Yeah, people don't object. There's a joint sequestration order. It's granted. Are you requesting an exception for your officer in charge? Any objection? DeJacmo.
No objection till I see.
Granted. All right, call your first witness.
So call Kevin Carter to the stand.
Oh, and Judge, just quickly, I did advise my client of the purpose of a preliminary examination, the fact that testimony will be preserved if an exam is held and he's elected to hold it, correct?
Yeah.
Thank you.
All right, let's go. Sir, if you can come on up when you get to the top of the stairs there, and I'm gonna ask you to face me and raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth so help you God? All right, have a seat in that chair. Sir, can you tell me your first and last name?
My first name is Kevin, last name is Carter, C-A-R.
Thank you, sir. Your witness, go ahead.
Can you please state, or here is something, correct? I'm gonna take you back to the date of July 4th, 2025. Were you at the location 103, City of Taylor, County of Wayne?
Yes.
What's at that location? Okay, and who else lives there with you at the house?
My wife, my grandson, my granddaughter, and John.
Okay, and what's your wife's name?
Her name is Tina.
How old is your name?
Tina.
All right, and I know that we have an individual in the courtroom. Is this individual someone who could potentially testify?
No.
No?
No, she wasn't there.
Ma'am, can you tell me your first and last name for the record?
Brittany D'Souza.
Spell the last name, please.
D as in dog, E-S-O-U-Z-A.
All right, great. Go ahead. Tina's at the house. Who else?
Tina, your granddaughter, what's her name and age?
Johnelle, she's 8.
8, and you indicated Johnny.
Just John's daughter.
Okay, and would that be the person sitting in the courtroom today?
Yes.
Judge, I'm not objecting.
It's preliminary. Go ahead.
Thank you, Your Honor. Let the record reflect that the witness has identified the defendant, Johnny Petaway.
Record shall so reflect.
And what, if anything, happened this day brings you to court?
I was attacked.
By who?
Johnny Petaway.
Okay, same person you just identified in the courtroom?
Yes, ma'am.
Attacked how?
He attacked me from the back. He hit me in the head, knocked me to the ground.
All right, so let's take this back. You were at home with your wife
Yes, ma'am.
and your granddaughter,
Yes, ma'am.
and Johnny was there that day as well.
Yes, ma'am.
What were you guys doing?
I was upstairs at the time.
Okay.
He was downstairs with his mom.
Okay, when you're saying he, are you referring to Johnny?
Johnny, yes.
So, because we need to have a clear record,
Yes,
just
ma'am.
use names, okay?
Johnny was downstairs with his mom and they were talking kind of loud. And I was upstairs and then I heard her tell him he's not supposed to be drinking.
Judge, objection, hearsay. Doesn't go to the truth of the matter asserted, but we can move on. Without telling me anything that you.
I would like a ruling on that.
Go ahead.
Overruled. Go.
Thank you.
For that limited purpose. Go.
So actually continue.
So I came downstairs and I told him he's not supposed to be drinking. He told me, why do I have it in the house? And I told
He
him,
said what?
why do I have it in the house?
Meaning
All right,
why
go
you have
ahead.
alcohol in the
Yes,
house? Okay, then what happens?
And I told him, this is my house. I can have what I want in my house. Then he proceeded to yell and scream at me.
Scream and yell at you, how, for what?
He was like, his words were like, you're not supposed to have this in the house. And I told him he doesn't live here. He's not supposed to be drinking.
Was he just staying with you for the day or spending the day there?
He wasn't living with me at all.
Okay, he was just visiting.
Visiting, yes, ma'am.
Okay, what happens next?
So I come off the stairs, I go in the kitchen, stand about hiding. He's yelling and screaming at me, told me he would beat my ass.
No, say, you can say it fully.
He said he would beat my ass.
Okay, then what happens?
And I told him, what you want to do? And he was like, I would kill you.
Okay, so before you get any further, you stated that you were near the island, correct?
Yes, ma'am.
And where was Johnny standing in relation to?
At that time, he was standing by his mom by the stairs.
Okay, how far away from where you are?
So from me to the officer to my
The
right.
officer, so I would say what, about 10 to 15 feet? Would you agree, Sister Counsel? From there to where the officer is?
From where the witness stand?
Yeah.
Yes, ma'am.
15.
15 feet? Yep. Okay, so about 15 feet away from you?
Yes, ma'am.
Okay, what happened?
And then I told him to just leave. His boat was telling him to leave. He wouldn't leave. Then he proceeds to come around and grabs a butcher knife.
Okay, so now Johnny's in the kitchen.
Yes, ma'am.
And where does he go in the kitchen to grab this butcher's knife?
It was while I'm standing there, I was by the refrigerator. The butcher knife was by the sink.
Okay, how far is that away from you?
So for me to maybe a little closer to where you at.
So closer than right here?
About 70 feet.
So where I am right now?
Yes, ma'am.
Okay, so about, I would say, probably.
He said 7 to 8 feet. He
Yeah.
testified. He gave us a distance.
Okay, what happens next?
He grabs the butcher knife, and I was on the phone with the 911 dispatch at the time.
Okay,
He proceeds to walk around to front of me with the butcher knife in his hand.
okay.
I grab a chair and lift the chair up.
So at this point, he comes around near you.
Yes, ma'am.
Is he facing you?
Yes, ma'am.
Face to face?
Yes, ma'am.
And is he still holding the butcher's knife?
Yes, ma'am.
What does it look like?
Huh?
What does it look like?
It was probably about 10 inches long.
Let the record reflect that the witness is gesturing with his hands about 10 inches long.
Yes,
Okay,
ma'am.
and then what happened?
He came at me, but I pulled the chair up to keep him away from me.
So, let the record reflect, what are you holding up actually? What are you
I have
gesturing?
a bar stool.
A bar stool.
Yes,
Let
ma'am.
the record reflect that the witness is just gesturing with his hand that he's holding up a bar stool.
Record shall so reflect.
Thank you, Your Honor. What is Johnny doing with this knife when he comes at you?
He's actually coming at me with the knife in his hand
Okay, is the blade towards you
Yes,
or
ma'am.
away from you?
toward me.
Towards you.
Yes, ma'am.
Okay, then what happens?
Then by that time, his mother was yelling and screaming at him. He takes the knife and he throws it on the counter.
Okay,
Then she grabs the knife and she tosses it in the sink.
who does?
His mother.
Okay,
So-
His mother, your wife?
Yes, ma'am.
All right.
So as I panned away from where he was at to see where she was at, I panned back, he wasn't there anymore. As I went to
I'm gonna
turn.
stop you there for a second and go back just a little bit. When Johnny was approaching you with that knife
Yes, ma'am.
and when he held it to you,
Yes, ma'am.
what did you feel in that moment?
Threatened
Why?
because I thought he was going to kill me.
Did you fear for your life?
Yes, I did.
Did you believe that he might actually harm you with this knife?
Judge, I'm gonna object leading. That's
Preliminary, Your Honor.
I mean, no, at that point, it's sustained.
Both questions, she rapid.
I didn't hear the answer to either one of those two questions, but the last two questions were leading. He asked him how he felt. He said he was in fear of his life because he thought he was going to stab him. And then after that,
I asked him, did you believe that he was gonna harm you?
No, kill you, I think.
Because he said he was gonna kill me. I'm following up on his own words. That's not leading.
no, the format of it was, I mean, the way you asked it was.
Okay. Based on Johnny's words to you, did you believe he was going to harm you?
Yes,
Why?
because he had anger in his heart.
Okay. And what happened after that?
By that time, when I looked up, his mother had grabbed the knife and I panned away to see where he was at. Then as I turned back around, I didn't see him by the stairs. He was yelling telling his mother to get me out of here. I said, no, you leave, you're not getting in my kill.
Okay.
Then by that time, I turned my head again, he's behind me.
How do you know that it's Johnny behind you?
Because there's only 3 of us in the house at that time. By that time, his daughter was upstairs.
Okay.
And Judge, I'm just going to object to his response. His own testimony indicates that it's based on speculation and an assumption.
Well, Your Honor, I'm fleshing this out.
Overruled, go ahead.
At some point, do you see that it's Johnny behind you?
Yes, ma'am.
When?
When I turned around and panned to see his face, that's when he hits me in the back of the head.
What does he hit you with?
I don't know.
Okay. What does it feel like?
It was hard.
Okay. And then what happens?
I hit the ground.
So you fell because
Yes,
of the
ma'am.
head?
Yes, ma'am.
What happened next?
But then when he get up, he jumps on top of me, he punches me in the head 15 to 20 times.
Okay. At this point, is your face on the floor or are you facing Johnny?
So I'm on the ground like this.
Okay. You're looking away from him?
No, I'm looking toward the ground.
Toward the
And I just had surgery to my eye, so I was protecting my eye.
To which eye?
My left eye.
Your left eye. Let the record reflect that the witness is gesturing with both hands in like a protective V position with his fist on his forehead.
Yes, ma'am.
Is that the position you were in as Johnny was throwing punches at you?
Yes, ma'am.
Okay, and was he, to your recollection, doing this with open fist or closed fist?
Close fist.
Closed fist. How many punches would you say?
I calculated 15 to 20 punches.
Okay, and they were making contact with your arms
My
as you
head
showed
and
us?
my arm, yes, ma'am.
Okay,
And
Did
by that
anything happen
time,
after that?
when
I'm sorry, could we have one at a time?
what happened after that?
his mother jumps on top of my head. And
Okay,
when she jumps on top of me, he stops punching me. He kicked me in my right side 3 times. He stumped me and kicked me on my left side 7 to 8 times.
Can you see him doing this?
I felt him.
Okay, were you still on the ground?
Yes, ma'am.
Okay, and what happened next?
Then I felt all the movement stop. I went to lift my head up. He punches me in the face 3 times and runs off the door.
Okay, what happens after that?
I was still on the phone when I went dispatch, and then I was in pain. But you know, at the time, the police had came.
Okay,
The police came. They took a statement from me.
so let me ask you this, when the police arrived, were you able to get back up on your feet at that point?
Yes, ma'am.
Okay, were you able to walk around?
Yes, I was.
Were you able to move around?
Yes, I was.
Okay, how were you feeling at that time?
At the time, I was in a little pain. The pain
Okay.
wasn't severe at that time because my adrenaline was so high.
Okay, and so when the police arrived, what do you do?
Yeah, I sat down in the chair by the front door, and there was actually questions, and I gave a statement. The officer said, do I want to go to emergency, to the hospital? I said, no, I can't afford an ambulance.
An ambulance?
Yes, ma'am.
Okay, so at any point, do you tell them what happened to you?
Yes, ma'am.
What happens next?
Then the officer said, okay, what was his description? What did he have on?
Mhm.
I say he had on boots, he had on a black tracksuit with no shirt, and his hair was wild.
Okay.
His hair was what?
Wild, like afro.
If the roof on your home has a leak or has missing shingles, that's an incredibly frustrating situation.
Did you provide him with any other ways to find him?
Yes.
How?
I told him he stays off of North Line Road. At the time, I couldn't remember the name of the apartment complex.
Okay. And then at some point, do you actually get medical treatment?
Yes,
When?
I went to Fairlane.
And Judge, I'm just gonna object to the question on the grounds of relevance. Injury is not an element of either offense with which the defendant presently stands charged.
I mean, Your Honor, sister counsel can't have it both ways. You can't say, I want medical records, and then say, well, injury.
Well, she didn't get the medical records. I mean, I just heard testimony that the guy, or that the defendant came at him with a knife, and that the defendant then punched him 10 to 15 times, had him on the ground, kicked him in the ribs. I mean, I don't, if you want to just go briefly on that, but I don't necessarily need it.
Okay. Very briefly. At some point, do you get medical attention?
Yes,
And-
Henry Ford Hospital.
Okay, what day? What day do you go to Henry Ford
That
Hospital?
was July 4th, right about 5 o'clock.
Was it the same day?
Yes, ma'am.
Okay, why did you have to go to the hospital?
Because at the time I couldn't breathe.
Okay, and what if anything happened once you got there?
When I got there, that's when I had 4 broken ribs on my.
And Judge, I'm not object. It's premised on hearsay. He has no personal knowledge as to what the inside of his body may have contained, whether they be broken, fractured, etc. A doctor told him that.
It's noticed, Your Honor, this is something that was revealed to him by a medical professional, and this is something about his body that can testify.
It's hearsay though. He's testifying as to a diagnosis. He's saying that my ribs were in fact broken.
Saying he learned that. I mean, obviously he learned it from the physicians. I mean, it doesn't matter either way. I'm going to allow it, but that's it. Like, I don't, all I want to know is, did they keep you overnight?
Yes, they did.
All right.
That would have been my last question. Nothing further.
Cross.
Judge, his testimony, and I didn't know this before because there's no reference to it in the discovery materials, is that he was on the phone with 911 during the entirety of this alleged physical assault. I am asking now, based on his testimony, that we adjourn this matter so that I may obtain the 911 call. I think it may be inherently exculpatory.
Your Honor, I would object. We've had a PCC on this. This has not been brought up before, not requested before.
Is this in the investigator's report or in discovery that he indicated he was on the phone with 911?
The entire time?
I mean, did he indicate that the assault happened while he was on the phone? I mean, we don't even know if, I'm not adjourning because we don't even know if the call exists.
Well, she's
indicated that at first I thought it did not. I mean, if it would have happened in Detroit, it would have been gone by now.
Sure.
But she indicated her OIC may be able to locate the call and they're working on it, but it may be gone. And that's, something you get to argue in front of a jury
Potentially, but I'm not.
And the answer
Give
to
me a
that
minute.
is no, I don't see that in the report. Just by looking at it, there's no mention that he's on the 911 call.
Exactly, and I find this to be inherently problematic. I need that in order to effectively represent my client based on his own testimony.
Your Honor, discovery is ongoing. This is now a question of fact. His testimony is there. She can cross-examine him all she wants, but it's not gonna change anything that would change a question of fact here. We're here for his testimony. His credibility is something she can question. If these don't exist, we're adjourning for like a 7th time on this exam.
This is my first request for an adjournment. He had prior counsel. It is absolutely necessary under People versus Anderson. The court can obviously take credibility into account at a preliminary examination. This evidence is clearly based on his testimony, critical for effective cross-examination. And the only thing I ever want to do in my job is effectively represent my clients. He is entitled to it, and I am asking you to adjourn, and I am asking for production of the 911 call. And just so the court knows, immediately when I was retained, I sent in a demand for discovery to the Wayne County Prosecutor's Office, where I demanded not only preservation of all recordings, body worn camera, 911, etc., but production. And I haven't received it. Clearly, my understanding, based on my review of the discovery, is that he just called 911. Now this has transitioned into an allegation that he was literally on a recorded line throughout the entirety of the incident that forms the basis for the instant case.
And if I may, Your Honor, once we got that discovery report, I myself, actually, my office sends discovery. I sent it myself twice. Whatever he said about the 911 call is his words in the video discovery, which if she reviewed, she'd know. So it's not in the paper, but he does mention that to the police. The people do not have the 911 calls. I cannot produce something that I do not have. So discovery is ongoing.
And we don't even
Whatever
know
he
if it
knows to share.
exists. Well, you've made your objection for the record. We're proceeding with cross-examination. Your objection's noted.
Peter Pan here. You know, I thought growing up would be the worst. Bills, responsibility, pants. But then I found a way to hack adulthood. It's called AAA. Grown-up perks, zero grown-up stress. Woo! Insurance and roadside assistance? Hey, yep. Oh! It's cool. I've got AAA. And don't forget, epic discounts on dining and travel. With AAA, it pays to be a member. A little more whipped cream, please? Yeah.
Actors, we can make you believe we know what we're doing, when in fact, we do not. Whoops, I have no idea what these buttons do.
I've never driven a stick in my life, but my heart is full yet!
Small business owner, because I have no idea what I'm doing. But GoDaddy Aero does, using AI to build a logo, website, and
Good afternoon, sir. Sir, you know Johnny Petaway because he's your stepson, correct?
Yes, ma'am.
You are in fact married to his mother, Tina Carr, correct? How long have you been married to her?
We celebrate 25 years September 16th.
So a long time. Congratulations. Now, obviously, Johnny's been in your life throughout the entirety of your marriage, fair?
Yes, ma'am.
You would agree with me that you and him do not have the best relationship, correct?
Yes.
You are not particularly fond of him, correct?
Sorry?
You're not fond of Johnny. You don't like Johnny, fair? Okay. You would agree with me that you and your wife have had numerous arguments exclusively relating to Mr. Petaway, fair?
Yes.
And you expressed, or it was your position, that you don't want Johnny around, you don't want her doing things for Johnny, correct?
Yes.
Now, obviously, it's a bother to you when Johnny's around, fair?
Yes.
And he was around on July 4th of this year, correct?
Yes, ma'am.
At the residence you live at with your wife, correct?
Yes.
Now, the defendant was not living with you at any point in time in July of 2025.
No.
And that is because you would not allow it, fair?
No, that's not true.
Okay. Did you know anything about his living arrangements at the time?
Yes.
I'm gonna object to the relevance of this.
I'm getting there. I'm getting there.
I'm gonna give her some leeway.
So you knew things about his living arrangements at this time, right?
Yes.
You knew he was living in an apartment, fair?
Yes.
You knew that his lease was up on that apartment.
I'm
That I
gonna,
didn't know.
I'm gonna, if he knows the answer, your objection's noted, overruled. I'm gonna give her some leeway. I don't know where she's going.
Did you know that he was no longer going to be able to live at the apartment he was residing at?
Yes.
Okay. Meaning he didn't have a place to live in the near future, correct?
Yes.
And that was concerning to you because you knew that his mother would want him to stay with you
Objection.
and her at the house.
speculation, this is like speculation within speculation.
He can say he doesn't know.
If the mom,
Wait, the question is, did he think that? Or
Yes.
did the mom think that?
You knew. That's how I started the question.
did you know that the mom's gonna want him to live there?
No.
All right, he answered it. Go.
Okay.
Next.
Now, you knew that Mr. Petaway was on parole in July of 2025, correct?
Yes.
And you knew that as a term of his parole, he was subject to a number of conditions, fair?
Yes.
And you were consciously aware of those because you were interested, correct?
I'm sorry, repeat the question.
You knew about the conditions of his parole because you were interested in what they were.
No.
Okay. How do you know about them?
I just know bits and pieces of it from what my mother told me.
Well, you do know that if he violates any of those conditions, he can face serious
No,
consequences.
object to speculation, he wouldn't know.
Do you know? I can ask.
Hold on, both of you can't talk over each other. But okay, your objection is that she's asking him to speculate. What is your response?
It is a leading question. It is proper. He can say no, yes, I don't know.
Ask the
Or you're
question.
wrong.
Ask the question again.
Sir, you knew that if Mr. Petaway violated any conditions of his parole, he could face serious consequences,
I
right?
didn't know.
You
You
didn't
did
know?
not know that, sir?
Yeah, I know that.
You did, okay.
Meaning you knew that he could be locked up if he violated parole, right?
Yes.
And you knew that one of his parole conditions was no alcohol consumption, right? And that if he violated, he could go to jail, right? And he wouldn't be around you or your wife, right?
You can state the question, please.
Okay, if he's in jail, he wouldn't be around you or your wife, right? And your wife wouldn't treat him like a child and do things for him, fair?
I don't understand.
Okay, I'll move on, thank you. Were you aware that Mr. Petaway was eligible to get off parole early?
3 signs your car accident is worth major compensation. If you've been in a car accident,
Now, you claim that an incident occurred at your residence on the 4th of July, right?
Yes.
You claim that you, your wife, Ms. Carr, and Mr. Petaway were present in relevant part, correct?
Yes.
Is Miss Carr the child?
That's
No,
my wife.
All right,
his mom, his wife.
all right.
Now, sir, I just want to go over the layout of your house. It's 2 floors, right?
Yes, ma'am.
Entrance is on the 1st floor, correct?
Yes, ma'am.
When you enter the front door, there's a living room, right?
Yes.
That living room extends into a kitchen area,
Yes.
correct? in between the living room and kitchen, there's an island.
Correct.
In between the living room and kitchen, which are effectively one room, there is a staircase that leads to the second floor, right? And the island obviously has two accessible sides, meaning one that connects into the living room, right?
Yes.
And the other that connects into the kitchen, meaning by the fridge, by the sink, etc. Correct?
Yeah, there's two sides to get, the island sits in the middle, there's two sides on both sides of the kitchen.
I understand that. Okay, but if you're looking at the kitchen from the living room.
You can see both sides.
Exactly. And one side is near the fridge and the sink, and the other side is near the living room.
No.
So no?
There's one side near the refrigerator, there's one side near the kitchen where the dining table. There's a side by the sink, and there's a side by the living room. It sits directly in the middle, so it's 4 different sides.
So it's it, okay, wait, so I understand. So the island's in the middle. If I'm at your front door
Yeah.
and I walk in,
Yes,
I'm in your living room.
Yes, ma'am.
I can see the island right in front of me.
Yes, you can.
And if I'm standing at your front door looking, behind me is the kitchen, or in front of me would be the kitchen. Okay, the sink over there. And then on the left side, what would I see?
Refrigerator and
All right.
dining table.
Okay, got it. Thank you. Now, at some point in time during July 4th, Johnny comes over, right? Do you recall, please say yes or no?
Yes.
Do you recall what time he came over?
To my knowledge, it's about 2 o'clock.
Okay. Now, obviously, because you don't like Johnny being around, you weren't happy that he came over.
That's not true.
Okay. Now, after he arrives, he's just hanging out, right?
Yes, ma'am.
Hanging out with his mother, fair?
Yes.
You're upstairs, correct?
Yes.
Are you drinking any alcohol on this date?
No, ma'am.
Now, at some point in time, you hear Johnny and his mother communicating, right?
Yes.
And they were communicating about alcohol, fair?
Yes.
How long had he been at the house at the time you heard that?
We was at the house, to my knowledge, probably about an hour.
Okay. Now, this was just a conversation, fair?
Sorry.
Meaning what you heard was him talking to his mom,
Very
right?
loudly, yes.
Okay.
Very what?
Loudly.
Okay.
Well, you know Johnny, and you know Johnny can be loud, right?
Yes.
Okay. So that's not out of the ordinary, correct?
No, no.
Okay. You did not see him doing anything wrong towards his mother or towards your house while you were upstairs, right?
Well, how can I see him on the stairs?
Okay. You just simply heard this discussion about alcohol.
Yes, ma'am.
Now, you knew at that point that he is not supposed to be around alcohol or drink alcohol as a condition of parole, right?
Question asked and answered.
Sustained. Go ahead. Next question.
Moving on, thank you. Your wife didn't ask for you to come downstairs, did she?
No.
You just simply decided to, right?
Yes.
And you had your phone with you when you went downstairs, correct? You had it in your hand, actually, correct?
Yes.
Now, when you come downstairs, you initiate contact with Johnny, right?
Yes.
And you do that by making a statement to him.
Yes.
And that statement was, you're not supposed to be drinking, correct?
Yes.
Did you see him drinking?
Yes.
What was he drinking?
A wine cooler.
Okay. Do you confiscate that from him?
He put it on the floor.
Okay. Now, you and him go back and forth, right?
Yes.
Verbally arguing, correct? At that point in time, you tell him you're going to call the police, right?
Yes.
And that is simply because he's around alcohol and he's drinking.
No.
Because you were arguing with him?
He threatened me.
Hey, No. Now, you actually call the police at that time.
I called the police after he threatened me.
Okay. And you tell the police, from your perspective, what's going on.
Yes.
I'm assuming that you told the police that he threatened you.
Yes.
Did you tell the police he was drinking?
No.
Now, obviously, you knew that the police would likely come in response to your 911 call, meaning come to your house. And you knew that Johnny would be in trouble and likely be removed from your house by the police.
Yes.
Now, during this verbal argument, you would agree with me that Johnny wanted to leave your house.
No.
So it's your position that even though you're calling 911 in his presence, he doesn't try to leave or want to leave.
I'm gonna object to the want to leave. That's speculative. He doesn't know what it's in Johnny.
How about this? Did he make an attempt to leave while you were calling? All right.
You're obviously on the phone in front of Mr. Petaway, right?
Yes.
And he can hear what you're saying because you're in close proximity. And you're telling me that while he knows you're on the phone with law enforcement, he begins to physically assault you or threaten you with a knife.
Yes, ma'am.
Okay. Now, it's your position that the first thing that occurs during the alleged incident is that he goes and retrieves a knife.
Repeat the question, please.
Is it your position that the first thing that occurs during the alleged incident, aside from the argument, is him going and retrieving a knife?
Yes, ma'am.
Okay. Prior to that, had you engaged in any sort of physical action towards him?
No.
Had you threatened him?
No.
In order to grab the knife, he would have had to go around the island.
Yes.
There. And where are you located at the time he goes around the island?
I was on the opposite side of the island.
Okay, so the island's in between both of you.
Yes.
And the knives are in a butcher block?
Yes, ma'am.
Which is visible.
Yes.
Which you could see from where you were standing while you were on the phone.
Yes.
So you knew as he was going to the butcher block that he could be retrieving a knife.
Yes.
Okay, do you tell the police, I see him going towards a butcher block, I think he's going to grab a knife?
No.
Do you make any attempt at that point in time to exit the house?
No.
Obviously, you were scared when he had the knife, right?
Yes.
And you would have been scared if you saw him going to grab a knife.
Yes.
Yet you take no action to extricate yourself from the situation.
Question is, how can I? He's standing with a knife in my head toward me.
Well, the island is between you as you see him going to grab the knife.
He came, grabbed the knife. He walks around the island. At that time, he was within 5 feet of me. So how was I supposed to run to the door? He's standing in front of me.
I understand that's your position. Now, you, as you see him approaching closer to you with a knife, you don't try to leave the house.
Okay.
I'm assuming that you consistently updated the 911 dispatcher play-by-play on what was going on?
Yes.
You indicated he walked towards you.
Yes, he did.
He didn't charge at you, run towards you.
He came at me aggressively.
Okay. At that point in time, you're about 5 feet away from him.
When he came closer to me, we were less than 2 feet away from each other. That's when I grabbed the chair.
Okay. And we're talking a bar stool?
Yes, ma'am.
All right, look,
Which hand was he holding the knife in?
I can't recollect. I don't remember.
You can't remember what side it was on?
Because when he was coming at me, he had the knife in his hand like this. I don't, at the time, my adrenaline, I was feared for my life, so I just grabbed the chair. I just see the knife come at me. It could be his right hand.
Okay, but you don't know?
No.
Okay. Now, at this point, you still have your phone, and you're still on the phone with 911, right?
Yes.
And this is all while you're grabbing the bar stool and holding it in front of you to block him.
I had the bar stool in one hand, my phone in the other hand. Bar stool was in my left hand, my phone was in my right.
Okay, you would agree with me that throughout your testimony, you've made some physical movements to illustrate how you were holding the bar stool.
And holding it up like this.
Oh, that's how you're doing it now with one hand, but you would agree that you've made physical movements depicting it with two hands.
I don't agree.
Okay. Is this a metal bar stool?
It's aluminum, yes, ma'am.
Okay. So you're strong enough with one hand on the bar stool to pick it up, hold it up directly in front of you, and block someone who is allegedly coming at you with a knife,
yes.
all while on the phone.
Yes, ma'am.
You are successful with one hand in blocking Mr. Petaway,
yes,
fair? At that point in time, the knife is set down on the counter, fair?
Yes.
And your wife apparently retrieves it and discards it in the sink.
Yes.
You would agree with me that at no point in time during this incident did Johnny touch you with a knife?
No.
Fair? Didn't cut you, slash you,
no.
etc. Didn't stab you, correct?
Correct.
Didn't try to come around the bar stool and stab you?
He swung it at me, yes.
But it made no contact with you? At that point in time, you put the bar stool down?
Yes.
And do you change locations?
No, still the same spot.
Okay. Now, where is Johnny at the time you put the bar stool down?
He walked away toward the staircase.
So towards the front door?
No, nowhere near the front door.
Well, the kitchen is at the far.
The way the house is set up, the bar, here's the counter.
Mhm.
Less than 5 feet is the staircase going up to the second floor.
Sure.
The doors probably 20 yards, like maybe 10 yards from the kitchen.
Okay.
So the doors, like where that door is in, this is the counter. That's where the.
I understand.
and he's pointing to the courtroom door. I'm not sure the exact, the front door from the counter.
Yes, ma'am.
All right, go on, next
I
question.
understand, but the stairs are closer to the front door than they are to,
No.
let's say, the refrigerator.
No,
Okay. Now, is your back towards him at that point?
at that point, when he dropped the knife, I was facing him.
Okay. And you remain facing him
Yes.
the entire time?
No. When I panned away to look to see what was going on to my right, when I panned back to where he was standing at, he wasn't there anymore.
Okay.
Then as I panned around to my left again, that's when I noticed he hit me in the back of the head.
Okay, so you did not notice him prior to being hit in the head, come around you and get behind you?
No, I did not.
You did not see who actually hit you in the head?
Yes, I did.
Oh, you did?
From the corner of my eye, I seen him hit me. I hit the ground.
Okay, understood. Where were you struck?
I was struck in the back of the head.
Directly in the back?
Yes, ma'am.
Okay. You fell?
Yes, I did.
Describe how you fell.
Face first.
Okay, so face down, right? But it's your claim that Mr. Petaway immediately began punching you in the face.
This is correct. I never said the face.
So he punches you, I think you said 25 to 30 times?
I did not say that either.
Okay,
I said 15 to 20 times.
okay. And as he's punching you, you're just laying there counting each punch?
As a person laying on the ground protecting himself, yes, I did.
He makes contact with your head and your face.
Yes, ma'am.
Were you wearing glasses on this day?
Yes, I was.
Okay. And those remained on throughout the entirety of
No,
the?
he knocked them off.
Okay. So I'm assuming, sir, that he was punching you quite hard.
Yes, he was.
Okay. And it hurt.
Yes, he did.
Did he strike you in the nose?
No.
Did he strike you in the eye?
Yes.
Did he strike you in the mouth?
No.
Counsel, how much more do you have?
I'm almost finished.
All right.
Sir, at any point in time, while he is punching you, I'm sorry, 15 to 20 times, do you begin to bleed?
I did not.
Okay. Now, it is also your claim that Mr. Petaway strikes you in the abdomen?
No, I did not say that.
Okay, stomach area, your
I
body?
said stomach.
Okay, so where does he strike you?
My ribs.
Okay. Which you would agree with me are in your torso, around your stomach?
We know where ribs are.
Good. Go ahead.
He did not punch me. He stomped and kicked me in my ribs.
When you say stomp,
Yes.
Okay.
Stomped down, he kicks like he's kicking a fool.
okay. And you're simply allowing this to occur?
How can I do anything with his mother laying across my head?
I'm sorry?
His mother was laying across my head as he got to punching me. To protect my face.
Okay, well, no one was restraining your arms, right?
I was protecting myself.
Okay, so your arms were up, his mom's on top of your head and your arms, and you're just simply laying there,
Yes, ma'am.
allowing yourself to be kicked and or stomped repeatedly.
Objection to the question. She's saying he's allowing himself to get assaulted.
Well, that's a fact.
I mean, it's argumentative, period, and it's also,
Mischaracterizing.
I mean, it's a form of re-victimization against the allegations. He's just allowing himself to be kicked. He testified, he's punched in the head 15 to 20 times. He's covering himself because he had just had eye surgery, and his wife gets on top of him to stop her son from punching him repeatedly in the head. And I mean, to say he's just letting this happen, but that's fine. Go, next question.
Sir, did you ever attempt to kick Mr. Petaway while he was doing this?
No, ma'am.
Okay, no one was holding your legs down and preventing you from doing that, right?
No, ma'am.
And during this entire period of time, you're still on the phone with 911, right?
At that time, I didn't know what the phone was out of my hands, so I don't know if I was still on the phone at that time.
Okay, you never took an app to hang up the phone, fair?
The phone was knocked out of my hand.
I understand, you never actually ended the call.
The worst.
Now, before the alleged punching, the alleged kicking, the alleged stomping, it was your testimony that Johnny asked his mother to take him away from the residence.
Yes.
And you prevented her from doing that by indicating that she was not permitted to use your vehicle to take him where he wanted to go.
Yes.
You knew that he didn't have another ride away from your residence, right?
He walked there, he could walk home.
Okay. He leaves.
Sorry?
He leaves.
He runs up the house.
Okay, so this alleged assault just stops because he decides he's done effectively? And I know you don't know that, but it just stops abruptly at some point. Okay. Do you call 911 a second time?
No.
At some point, the police do in fact respond to your residence, right?
Yes.
And you actually stand up and answer the door.
Yes.
You invite the police into your residence, correct?
Yes.
Johnny's not there.
No.
And you stand there for an extended period of time talking to the police, right? You had no problem speaking at that point, correct? You weren't out of breath, fair?
Fair.
During your communications with law enforcement, you actually volunteer to walk around the house and retrieve, let's say, a photograph of Johnny, right?
This is true.
And you had no problem walking to do that. During your communications, you're actually lifting both arms to direct the police where things allegedly occurred, correct?
Yes.
And you didn't have any problem doing that, correct?
Correct.
During your discussion with the police, you promptly tell them that Mr. Petaway is on parole, correct? And that was important for you to communicate to them, right?
Yes.
Why?
Because he attacked me.
And if you told the police that.
Move on.
During your contact with law enforcement, you would agree, sir, you didn't have any visible injuries to your person.
Excuse me?
You didn't have any visible injuries to your person.
To my knowledge, I didn't know.
Oh.
He said he doesn't know.
Okay.
To his knowledge, he doesn't know.
The police actually examined your body, fair?
No, they did not.
They never asked you to lift up your shirt?
No. Wait, yes, they did.
Okay, and you did,
Yes, sir.
right? And they examined your body.
They just looked at me. didn't
Okay,
touch
they
me.
looked at your body.
Yes, yes, ma'am.
Okay.
He asked
You
me-
would,
He asked me where was I hurting at, and I pointed to it.
okay, and you only showed him a single side of your body,
Yes, ma'am.
not both,
No.
meaning right and left.
Yes.
You had no cuts, abrasions on your person.
I had a black eye.
Did the police take any photographs of you? Did the police request that you take photographs of yourself?
No.
Now, the police specifically asked you if you would like medical treatment,
Yes.
and you declined.
I declined because I didn't want to go in an ambulance. I ended up taking myself to the ER.
Now, they actually have you complete a written statement. Yes?
Yes.
Okay. And you do,
I'm sorry.
and you do.
I do what?
You complete a written statement.
Yes, I went at the house again.
Okay, and you only told the police the truth about what happened, right?
All right, we're gonna have to.
Judge, I have two more questions too.
All right, I mean, my court reporter we've got 11 minutes. We can be.
We're gonna be done.
Okay, well.
I assure you. Now, sir, you went to the hospital that very day.
Yes.
And it's your position that you were told by a medical professional that you had fractured ribs, right?
Broken ribs, yes.
Okay. Have you ever broken your ribs or a rib before?
No.
Were you involved in a car accident?
Yes, I was.
Did you break any bones?
Foot, hip, shoulder.
Do you work?
Every day.
What do you do?
I'm a sales rep for a roofing company.
Okay, you're not actually a roofer?
No, ma'am.
Okay, you immediately returned to work after the 4th of July holiday?
No, ma'am.
You did not? Take a leave of absence?
I was off for weeks.
Okay.
Why I get triggered when someone gives me unsolicited.
I have no further questions for this witness.
Madam Prosecutor, any redirect? All right, this witness is excused. Thank you, sir. You're all set. All right, any further witnesses?
No, before us.
Counsel.
I have no witnesses. Who provide over as charged, reserve argument for rebuttal.
Judge, I'm objecting to bind over. I'm asking that you consider dismissal of the instant case, both charges. I do not believe that the people have sustained their burden, even under a probable cause standard, based on the testimony that's been presented. Let's look at elements here. I don't believe that the testimony was sufficient to establish an intent a specific intent to cause great bodily harm. Plus, I think there are significant issues with credibility as it relates to this witness. I know that the court may take his statements at face value, but when you break this down, when you look at his actual allegations, they are not supported by any objective evidence that has been presented. There are no photographs depicting that he had any injuries. I mean, by his own testimony, he effectively acknowledged and then changed his story regarding whether or not he had any physical manifestations of injury. Think about being stomped on, think about being kicked, think about being punched 25 to 30 times in the face. You know that if there was an injury, the police would have taken a photograph of it. The bottom line is, I think under People versus Anderson, you can assess credibility, and I assert that his testimony was not credible, and I'm asking that you dismiss the case.
All right, well, I saw that a lot differently. Madam Prosecutor, you don't need to respond. Quite frankly, Mr. Carr is the most credible witness I've seen in months. Mr. Carr was on point. He stated the facts. He didn't get mixed up. His story was consistent the whole way through while he testified. I thought he did a very good job at testifying. He was a good witness, period. He was very consistent. He admitted his fault. He admitted, he doesn't really like Mr. Petaway, doesn't really like him, doesn't want him living with him, doesn't want mom taking him in the car. I mean, he didn't try and conceal his, feelings. He testified that the defendant grabbed a knife, came at him with a butcher's knife, eventually put it down on the counter, and then he punched him multiple times on his head, 15 to 20 times, and then he kicked and stomped on his ribs. And on direct, you objected to the defense counsel objected to the fact that he testified he had 4 broken ribs, but then questions were asked with him on cross-examination about the 4 broken ribs, so I'm certainly going to consider that. He also testified he didn't want to go to the hospital because he didn't want to take an ambulance. Nobody in the United States of America wants to take an ambulance because we can't afford them. So he drove himself to the emergency room or had someone take him. He testified he went to the emergency room later that night. He testified they kept him overnight. I mean, for a probable cause standard, people aren't required to have a bunch of corroborating evidence. It comes down to witness credibility. I found it to be very credible. I did. I know. You looked at me like I was crazy.
No,
I'm just saying,
like you're crazy.
Sir, you're bound over to the Third Circuit Court on the charges as written in the complaint and warrant. Since you're in custody, your arraignment on the information will be October 22nd of 2025. And that concludes today's hearing. Thank you. Thank you. Thank you.
Well, that's it for today, everybody. Tomorrow I have a doctor's appointment, but I will come on tomorrow evening for a coffee chat. That might be 30 minutes, an hour, I don't know. That depends. But that's it for today, everybody. I broadcast normally every day at 3:00 p.m. Central Time. I want to welcome all the new subscribers to this channel. Thank you so much for your support. But we can get up to 500 subscribers by the end of this year. I know we can do it. So let's keep working on that. And like I said, that's it for today. I will see you guys tomorrow at 7:00 p.m. Ta-ta and ciao ciao, and have a wonderful evening.